can you please look up this site?
See if we can figure out something. Case people versus Dominic Kelly Payne.
This is public defender in an Apple hearing on behalf of Mr. Kelly. Mr. Kelly, can you please state your name for the record? Thank you. Your Honor, this is a waiver on all four files.
All right. Is that correct, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. All right. You understand that you will not have that hearing, that you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court. I think they're all individual. On all felony charges. I think it's actually all of the cases, all of the charges. Well, no. In case 5219, he's bound over on count 1 and 2 with 3 following.
Your Honor, at this time, we would acknowledge the information. My client stating that he has this matter for his colleague.
Defendant having waived formal reading, standing mute to all charges. Court will enter a not guilty plea. Pretrial in these cases will be set for
September 26th at 1:30 before Judge Slate Thursday.
September 26, 2024, 1:30, Slade Thursday.
And Your Honor, for the record, a referral to drug treatment court was made on my client's behalf.
Okay. Okay. We just don't know where it's at right now.
No, it was just made yesterday. So.
Got it. Okay. Bond will continue. Good luck to you. Sir. You're welcome, sir. There you go. Court calls case of the people versus Omar Durant.
Mr. Durant. Sorry, I was not ready to had a college cousin said. Mr. Childers had made an offer in this case. I was hoping to waive it. Not here again, so I'm waiting. So I guess
Is he gonna waive?
He was gonna waive, so I was gonna treat the circuit court. To plead one count, that one count dismissed.
All right. Is all of that correct, Mr. Durant?
Yes, Your Honor.
All right, and you're gonna waive your right to have a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
All right. You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over circuit court on both counts. Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
October 23rd at 1:30 before Judge Conley.
October 23rd, 2024, 1:30, Judge Conley. Thank you. Bond will continue. Thank you, sir.
Thank you.
Case people versus Michael Kyle. They need
Ready to enter. Crucial piece of assistant public defender, Mr. Michael Kyle, Mr. Kyle, Mr.
Thank you, sir.
Your Honor, one time, it's a matter of my understanding, there are some jail calls coming from force coming. I have not yet received, I think you might have a request to that. You know, our client's gonna be asking you for a moment to determine if you see if possible. to get a copy of the calls.
I'm gonna be candid, I've not reviewed the calls, I've just been told that he's in contact with the victim, she had to change her number, so I have not reviewed any calls yet.
But you've been informed that the,
Correct.
Obviously, my client advises what we're waiting.
denies contact at all? All right, well, what I'll do in the interim is I'll restrict the defendant's phone privileges. I'll put him out 1 week. Now, sir, if you want to act that way, we can get the phone calls and start listening to them now. I don't know you want me to do that, because if there's an attempted contact, we're done. I'll turn it out 1 week instead of the 2, so I'll go to the 19. That way, Mr. Feaster, you can look at all of that and figure out where we're going on that. All right, bond will continue temporarily. Defendant's phone privileges are hereby ordered revoked pending a hearing.
Thank you, Judge.
Thank you. No, it's okay. I got you. I got you. You got a lot going on. Yes, that was that. That one right there. Court calls case People versus April Easterling. Is that Miss Easterling?
Says about the country south of life, you have to make what he's doing. Yeah, sometimes I will contact you. Contacting her, I would ask once here in 1 week.
Last time we were here, there was a probably like that.
Hospital.
I don't know if we had any follow up.
We can adjourn when we start to do that.
I'll issue a bench warrant and then you can get the information and we can figure it out. I heard it the last time, 10,000 cash surety. That warrant will issue immediately. That was where we focus.
Yes.
Yes. Case People versus Walter LaCroix.
You interject that, please, Steve.
Judge, Court trustees for Assistant Public Defender, Penalty Capital, Mr. Walter LaCroix. Mr. LaCroix, please come forward and take your name.
Thank you.
Thank you, Judge. I have Mr. Ellis on this case. He has been his guidelines on the file. This is the risk of use of the man declined to a private drug test. I know my client does want to be released, but I hope that not done so likely. So I am asking for adjournment, Your Honor, so that we can discuss the guidelines offered Mr. Ellis made.
Probable cause conference, September 26, 2024, 9 a.m. Bond continue. Thank you. Court calls case People versus Devon. Is it Devon Ellis?
Charles, will you please read the record?
Thank you, sir. Pardon? Good morning.
Your Honor, we're asking for an adjournment. Mr. Ellis has some mitigation information that we are getting submit to the prosecutor's office.
Okay, how much time do you think you're gonna need to?
2 weeks, Your Honor.
Why don't I do this? October 3rd, 2024, 9 a.m. Then we can get that to her and get that all wrapped up, okay? Bond continued. You're welcome.
Can you address the bond violation report?
There's a bond violation. Let's see. I don't have one.
Can I send that to somebody?
You can send it to Emily, but she'll get that with her 30 or fourth hand, because the other ones are busy, but go ahead. What? Yeah.
Positive alcohol result on his, sorry, I'm just looking to see if it's a sober, yeah, it's a sober link device. September 9th,
2024, he was positive for alcohol of 0.038 at 12:27 a.m. He then proceeded to miss 1, 2, 3, 4, 5, 6 requested retests. He then again failed to test on September 10th. But he did test on, so his time on September 10th from 6 a.m. to 9 a.m. That he did test at 9:12 a.m. and was negative on September 10th. So at 9 positive at 12:27 a.m. followed by failing to retest. There was a requested retest from all the way up to 3:12 a.m. Did not test at all during that time, and instead did not test again until 9:10 at 9:12 a.m. So the entire following day. I should also say this is not his first positive test. On week 19, he tested positive for alcohol, was a 0.033. 11:02 p.m. he retested. At 11:19 p.m. was a 0.03. Then he proceeded to miss a test 1, 2, 3, 4, 5 times that night. Did not test again until August 24th, which is when he was negative, and that is 5 days later. I'll send it to them.
Ms. Apple, have you seen that report?
I am, Your Honor. I'm reviewing that with my client now.
All right, why don't we do this? Because it looks like he would be remanded based upon that. I want to see the report myself. Take him back into custody and then you can talk with him. I'll call him back out later. All right? Thank you. That's on that one. Who else I got back there? Federico? Okay. Got it. Okay. Those just need signatures. Well, I don't.
Yes, those just need signatures.
You good? You got the next. Court does call the case of the people versus Brandon Morris. One of these, well, I'll do it. Go ahead.
Yeah, no worries. Yeah, some more data for the record. More.
Thank you, sir.
To adjourn the public that's submitted for us, so that's back. Been conversations with the prosecutor. Discussing everything.
How much time did you need to?
I can do it in 1 week. I know that's not great for the court, so 1 or 2 weeks.
Public cause conference, September 26, 2024, 9 a.m. Bond continued. Excuse me. Oh. That normally doesn't happen. Court calls the case people versus Lante Ford.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Ford. State your name, Mr. Ford.
Thank you.
Your Honor, I've had a chance to discuss this matter with you before. I submitted the papers during this, at the court's discretion to Dane. I'd like to do some mitigation.
Your Honor, if I could just make a record, I don't object to that request in part because prosecutor's office received a lab report from the police department. So it's a positive for cocaine as part of this investigation. So what I told Mr. Gaddy is there's a possible offer of either he leads to the charge and we don't add that count, or he waives in the circuit court and tries to work it out in circuit court. But there's more information that he doesn't discuss.
Got it.
That is correct, Your Honor. Thank you.
And then try to get October 10th, 2024, 9 a.m. Bond continued.
Thank you.
All right, thank you. Thank you, sir. Court calls case people versus Nicoa Nelson.
Assistant Public Defender Jay Bell, on behalf of Mr. Nelson. Yes. You know, you just take your name for the record.
All right. I have the request for more cases pending.
That is correct, Your Honor. I think they're trying to track cases at this point.
Of all, go ahead.
Don't know that yesterday I reviewed and authorized one felony case and possession of 25 grams. I also reviewed and authorized an assault and battery. Both are probably going to be typed out in the next day or two by our office.
Got it. Okay. Okay, let's do this then. See if we can get him back before the end of the month. I go 2 weeks out, 26, 2024, 9 a.m. Okay, time's out.
Release the treatment in all cases.
I do believe so, yes. Right, I think, yeah,
Okay. Thank you.
okay. And in fact, hold on a second. Have they been in contact with you about Sacred Heart yet, or no? Do you know if you're supposed to go into that treatment anytime soon, or
Next week.
next week? What time next week, do we know? Probably. Did they tell you anything? They won't give you this, right? Okay, so by the 26th, he may not be here, but I can't get him back here. Okay, we'll figure it out. Because I see that I signed the approval for release, which means I think there's a bed for him. It's just, okay. All right. Oh, we don't see you next 2 weeks. Good luck to you.
Thank you.
All right. Court does call the case, People versus Frank Green. He's yeah.
Say you're here.
Yes, I'm here, Your Honor.
State your name.
Frank Henry Green.
Okay. And these are all waivers.
Yes.
All right. Mr. Green,
Yes,
you're waiving your right to have preliminary examinations in these cases?
yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, sir.
You understand you won't have those hearings and you'll proceed to circuit court for further resolution, right?
Yes, sir.
Okay, people also waive their right.
Yes, Your Honor, thank you.
Preliminary examination having been waived. Defendant is bound over circuit court, I think, single counsel in each 5 cases. Defendant having waived from a reading standing mute, court will enter not guilty plea. Pretrial in these matters will be set for
October 22nd at 1:30 before Judge County.
October 22nd, 2024, 1:30.
Thank you, Your Honor. And it is my understanding, just for the record, that he has been approved from the drug treatment court, and upon waiver, he'll be admitted.
Okay.
Thank you.
I don't know why. my
And on all
attorney-
these matters will continue. Good luck to you, sir.
Okay, Your Honor. Your Honor.
Take care. Court
Okay.
calls the case, People versus Joshua Quick.
The water system, I know we have Mr. Quick is approaching custody. Mr. Quick, would you state your name for the record, please? Ryan Quick.
Go ahead.
Your Honor, I'd ask to adjourn the probable cause found present. There was a DVD that currently was picked up in my office, but that's not clear that anyone seems to know where it is. Additionally, there is some CSAM material that I need to review, so arrangements need to be made for that. I'm told I may need to go to Brighton or Lansing to do so.
October 3rd, 2024, 9 a.m.
Thank you, Judge.
Bond continued. Thank you, sir. Case, People versus Brian Hagard.
They don't know you have a Mr. Haggard with government.
Good morning. All right, what are we doing? You need an adjournment? Why?
We do. I just checked the prosecution, Your Honor. It's my understanding that they will have blood back within the next 4 to 6 weeks for the pending OWI matter. We are asking for an adjournment to track the cases.
Probable cause conference will be adjourned October 10th, 2024, 9 a.m. Bond continued. Thank you. Court calls case People versus Renard Scales.
Just to let you know, we have people.
Yeah, the assistant public defender on behalf of Scales, who's here to my right, Your Honor. State your name, Mr. Scales. Renard Scales.
Thank you.
Your Honor, we're here for. Your Honor.
Thank you for acknowledging that I know why I'm on the docket today, Mr. Haney. You need, is our all discovery complete, sir?
Yes, I believe so.
All right. People have their witnesses available the 24th. Preliminary examination in person will be September 24th, 2024, 9 a.m. before Judge Prer. In this matter will continue. Thank you. You're all set. Court calls case People versus Eric Harris.
In an apple appearing on behalf of Mr. Harris Jones. He has two files, Your Honor. One's under Harris.
Yep, he does. All right. Good morning, sir. You're requesting an adjournment in these cases?
I am, Your Honor, and I did wish to address one component of bond as well. We're asking the court's permission. He is testing at comprehensive treatment where he receives methadone. He states he can't afford the testing at Katy Corrections. I informed him yesterday to sign releases so that if the court would allow that those test results can be sent to Katy Corrections.
Yeah, I don't have a problem if you prepare an order, Ms. Apple. I'll sign off on that. Okay. And in these, how much time did you need?
Your Honor, if we could just have 2 to 3 weeks.
Okay. October 3rd, 2024, 9 a.m. All right. On both of these cases.
Thank you, Judge.
Okay. Thank you, Mr. Harris, Mr. Jones, whatever your name is. All right. All right. Go ahead, continue. Take care. Those case People versus Marshall Seal. He's
On behalf of Marshall Field.
say your name, state your name. Thank you. All right.
Your Honor, I've been in conversation with the prosecutor asking for 1 week adjournment until the further negotiations. And I did just.
Are you gonna get,
I think we're going to go.
19th, 2024, 9 a.m. as to bond.
This deal has been in for about 9 months. And we are asking that the penny is please on his personal record. Doesn't usually be doing
Because that's not gonna happen. I mean, he was in. I remember Mr. Seal when Mr. Seal was in bad shape. One of the things I will say last time, well, I noticed before, but also certainly last time, he is doing so much better right now. I mean, just incredibly. I don't know if you remember, Mr. Seal, we couldn't even have a conversation before.
Yeah, without medication, I could.
Yeah. Exactly. So I'm not released unless I have a plan in place as to what will happen and how he's gonna, I'm just telling you, I'm not gonna release him. I don't think Mr. Seal wants to go back into the world, and correct me if I'm wrong, Mr. Seal, where things aren't in place for him and get back to that spot where he was. I don't think he wants that at all.
I'm already set up with outpatient treatment with CMH,
Are you?
so, yeah, through
Oh.
the courts. So I have that. I do have treatment in place.
Okay, then do this. I won't say no forever. I'm not gonna do it today. If somebody will get all of that to me so I can see what it is and make sure things are, from my standpoint, make sure everything's in place, then I may not have an objection to his release.
And I was gonna just say the same thing, I mean, we had this discussion with Mr. Brown.
Yes, well, we were last here. All right. And you understand what I'm saying, Mr. Steele, right?
Yeah.
Okay, all right. See, I'm telling you, that conversation that we just had would not have happened last time. It's good to see you this way, Mr. Steele. All right. Fine, continued. We'll see you next week. Okay.
We are down to.
Okay.
And we have. And then. They do this. So we set up for.
Who's it? That's the guy that was talking. Said
Skinny guy down here.
he's the one that just came up. Yeah.
Yes.
So they want me to recall it?
Yeah.
You don't even have to.
He's a real criminal.
But, okay. Yeah. No, I think it's Ballinger that's causing me problems. Yeah, you, what do you mean, me? You spend all day trying to.
I said go church last week, and I'm here.
You know, we lost. Yeah, see, that was his way of trying to rub it in. Never mind, I'm not talking to you right now. I'm just,
You lost.
who was that?
Michigan?
Oh, that was not a game.
No, it's not a.
No, I don't know what that is. I don't know what that was. Maryland at least had offense.
No offense.
Let me try to do this. I think you're one gentleman who had a lot to say. You're trying to get that recall.
Yeah.
Yeah, probably a good thing. But let me figure out how we're gonna do that. Court, let's call the case people versus Dolores Strickland.
What is it? What's going to be the assistant public defender, current applicant, Lord Strickland? Thank you, Judge. We might call this Strickland, what's further comments? Came back, it was conference, my understanding. We're at the PCC storage, and Ms. Tanner asked that her offer, was that offer, and offer this Strickland wants. She had a specific offer that she just requested. And so he wanted to try and get the child, support its lips, and that's not a law. So journalists, for.
What she wants, I didn't like, the bargain that we had, made the first round, before the competency test. I totally.
Okay. No, I got, you want to tell me, but I don't know that you really want to tell me and have all of that out about what the negotiations are.
It's basically the same thing about what you just said, except for rehab.
So as I said, we're not selling it. If we could go out at least a week or two.
A week.
I know she wants us to leave us.
Because, Your Honor, I'm telling you now, I stopped my medication, my thyroid medication. That means yes, I stopped that. I skipped my meals that I cannot take it. I went over this whole thing.
She wants
I've been
to,
here 7 months.
she wants to resolve it.
I know, I think it probably,
No objection to the German.
I'm sure you guys will, thank you. After all that, finally, Tana like jumps in. Okay, September 19th, 2024, 9 a.m. Bond will continue. You can do those because I'm tired. I think I'm
We're down to.
We're down to all in custody.
One in his house.
Okay. Court does call the case of People versus Brandon Ventura. I don't know what you mean by that.
Andrew Schultz, attorney on behalf of people, assistant public defender, Dane, on behalf of Mr. Ventura. Mr. Ventura.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor, that is my understanding.
All right. Plea form indicates that the defendant would be pleading guilty to the charge to an added count 3. Oh, I'm sorry. He'd like to be pleading guilty to count 2, operating with a high BAC, and an added count 3 of attempted resisting and obstructing a police officer, 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's entire understanding of
That is
that.
our understanding.
All right, may I have him sworn?
You solemnly swear to tell the testimony about you and the truth, the whole truth, and nothing but the truth, so help you God.
All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding? First charge is that of operating with a high BAC. That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs, community service, and any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir? Also, it's this court's understanding you're going to be pleading guilty to an added count 3 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. Do you understand that? Now, understanding all of that, do you still wish to plead guilty to these charges? To the charge of operating with a high BAC, how do you plead? To the charge of attempted resisting and obstructing, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form today? Or previously? Okay. You have any question regarding any of those rights? Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will? And also because you believe that you are indeed guilty of these offenses? July 7, 2023, at the location of Main Street near East Shore Drive in Northfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle? Prior to operating that motor vehicle, did you consume intoxicating liquor? Did you know what you had and how much? Do you recall? What'd you have?
I had 2 double jack coats with a shotgun on the side for each one of them and 2 beers.
Wow. All right, were you stopped by the police? Why'd they stop you? All right. Were you ultimately arrested? And were you taken to the police station or hospital for a blood draw? Okay, there was a blood draw. And what were the results?
The exact results. I think it was 0.16 something around it.
Over 0.79.
0.199.
That's close. Do you have any reason to dispute those blood test results, sir? All right. And you had interaction, obviously, with police officers that day. You knew they were police officers. What did you do involving your involvement with the police officers, or what did you do?
Why my it was for me to do, so I knew that.
Oh, so they were trying to get you out of the car and they were giving you certain commands and you just weren't having any of it. So when you told them you weren't gonna do that. That didn't work out real well, did it? Yeah, I didn't think so. All right. Okay, counsel, have I complied with the court rule or would it be proper to accept this defendant? Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report as screening and assessment is ordered at 14:03. Sentencing in this matter will be
September 24th at 9 a.m. before Judge Fresh Hour.
September 24th, 2024, 9 a.m. before Judge Fresh Hour.
I may address bond.
Sure.
Thank you. There are, I will provide to the court that there are a couple of pieces of information that are too sensitive to put on the record. I don't know if the judge would entertain me approaching briefly to discuss those issues. But I will say that Mr. Ventura, his significant other is pregnant. She's in her first trimester. She was due to have twins. He did just lose one of the twins to miscarriage, Your Honor. He would like to be able he would be willing to do GPS tether, whatever the court indicates would be just fine with him. He's willing to test. He just would like to be able to bring support.
People's position.
Your Honor, I'm less concerned with the GPS stuff, as long as there's some alcohol test.
Interesting.
Scram or something.
And Your Honor, if we maybe request the portable so that he does have a job where he climbs ladders and tethering and get in the way of that, he would be requesting one of the portables. And the phone has
Climbs ladders where?
I do the 40-foot.
So a tether, a scram tether is gonna get in the way?
You want me to wear one? I'll wear
No, I was just going with the counsel's argument. He told me it was gonna get in the way climbing a ladder.
one. I just don't want.
Bellinger, when's the last time you climbed a ladder? Yeah, okay, that's what I got. You're all right. He's just making something up. Just get your leg around the rung, the next one, you're good. All right, what I'm gonna do is I will release the defendant from custody on a what's it on there currently? Hold on. Did you just do acting ruling? No, because you didn't appear at some point.
Failed to appear in early July.
Okay, I'll reinstate his bond at a 5,000. Personal recognizance. I'll order a scram tether unit. He'll figure out how to work that with the ladder. Okay. And all of your previous conditions, no alcohol, recreational marijuana, no illegal drugs. Understand that, sir? Okay, thank you. Court does call the case People versus William White.
Judge Mike Haney, assistant public defender on behalf of Mr. White, who's here for state unit.
Thank you. What are we doing?
At this time, we'd ask the court to set this.
All discovery is complete.
Yes, sir.
Have their witnesses available to 24. Preliminary examination in person, September 24th, 2024, 9 a.m. before Judge Washington.
I could be heard on.
Sure.
Your Honor, we're here on the DV cleared matter, Mr. White. I'm not going to go over Mr. White's on probation. He's not going to violate the file on that matter either. He is gainfully employed. He is a shift supervisor at Bakehouse 46. And has been there for some time. Does not reside or complaining witness, he lives on his own, at his own home.
But this case is a violation of a potential violation of probation.
Allegedly, yes, sir.
Is that probation that he's on for a domestic? Okay, go ahead. I don't need anything from the people. Motion for bond reductions tonight. Bond will continue. Thank you.
It's grandfather and.
Oh, I just did. Got it. Court does call the case People versus Andre Wiley.
Jessica Blanchard, people. Andre White, Assistant Public Defender. On time. Okay. On behalf of Andre White.
Your name, sir? You're requesting an adjournment?
About 2 weeks, Your Honor. The prosecutor and working for.
At objection, probable cause September 26, 2024, 9 a.m. Bond will continue in this case. Thank you.
Refusing.
He's refusing.
Yep.
To come in?
He doesn't want to see you.
He doesn't?
No.
Oh. Court does call the case of the People versus Cody Lee Jolly. He doesn't have a PD.
No, he's in program.
He's refusing to come out.
The other come out and.
Really? Hmm. Okay, well, I'll just adjourn this probable cause conference. Let's go October 3rd. Give him time to think about it. 9 a.m. bond continue. What?
Yeah. Recall.
We have recalls. Well, yeah, I've got those 2 recalls, but I don't know what. Is this Ellis? Ellis?
Yeah.
That's on that one. And what are they doing before we do that? What are they doing with their call?
I had Mr. Bernstein here. I don't know who. Oh, he's right there.
I'm here for the word, yes.
All right, get Mr. Ellis out. That's easier. So these are my only things for this block. These are my only things for this block. What are those?
He's interpreted.
So where are they?
The 2 are in custody. It's here.
So why am I recalling these right now?
I don't have an interpreter yet, so I.
Okay. So we're filling space.
We are.
Okay. That's fair. Are we ordering up an interpreter?
Yes.
Let's recall the case, People versus Ellis. There. And now have the report and have reviewed that in front of me. Counsel, anything you want to?
Your Honor, after having a conversation with my client, at this time, he does wish to admit to the bond violation. Mr. Ellis recently completed, beginning of August, Oakdale recovery inpatient. He's been on a wait list to get into transitional housing. He does acknowledge that he's still struggling with substance use. Based on that information, my conversation with Ms. Hughes, and that there will be no misdemeanor offer, Mr. Ellis does wish to waive his right to a preliminary examination today, proceed to circuit court, where we'd be asking for him to be released at a later date, assuming that the court would remain him on the violation to treatment.
So he wants to waive at this time?
Correct. And we'll work on getting verification of
All the
treatment
others.
in Oakdale, and giving that to the circuit court prosecutor.
Sir, is that correct? You want to waive your right to preliminary examination? All right, you understand that's a hearing where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have a hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination, having been the way defendant is found over to circuit court. On count 1, 2 with 3 and 4 following. Go ahead.
We would acknowledge receipt of the information, we formal reading, my comments.
Defendant every way formal reading, standing mute to all counts. Court will enter a not guilty plea. Pre-trial will be set
September 26th at 1:30 before Judge Slay Thursday.
September 26, 2024, 1:30 before Judge Slay Thursday, you said?
Yeah.
Slay Thursday. Defendant having admitted to the violations, at this time, I'm going to revoke the defendant's bond, remanded to custody. Would that be the date if he was in custody?
It is.
It is, okay. All right, so we got the soonest date we can for you up there. Young man, good luck to you.
Now we do have an interpreter.
We have an interpreter.
Yes.
Okay. Let's do it.
Good afternoon, Eileen. You're before the Honorable J. Frederick Simpson of the 14A1 District Court. Our number is 1433. Can you raise your right hand if you sworn?
A pre-sentence investigation report is ordered.
Y el precinto, la investigación es, la corte está siendo ordenado.
Sentencing will be September.
District Court for the County of Washington, State of Michigan is now back in session. You have Judge J. Cedric Simpson presiding.
You may be seated. All right, so that we're clear, Ms. Hughes, you have caused me great problems today. No, you don't have to move. But no, it's not you moving. See, you're in the wrong spot. Right? I was telling my staff, I said, she's normally there. I get why Lante's there. Miss Tana, she's here for a while, but then she leaves. And so people were just not where they were supposed to be, so.
Today, and I will continue, unfortunately, but however, the view from this side is so much better because.
What do you mean? I'm ugly from the front? What are you talking about? What? Wow, okay, I'm done with this conversation. We're over. Court calls the case. People versus Tpra Martin. Oh, and here you come.
There are 10 things that I want to say about. Erica Julian appearing on behalf of Tpra Martin. Just normally, please state your name for the record.
Tpra Martin.
Thank you, ma'am. All right, you're adjourning, working on a plea arrangement. How much time did you?
I think standard adjournment would, just have to.
Standard. September 26, 2024, 9 a.m. Bond will continue. All right, thank you, Ms. Martin.
For what it's worth, I think the entire board would agree that it was amazing.
I'm not even clear how to take that, so you just go sit down. No, I'm not talking to you anymore. I'm done. I am so done. Thank you, Miss Julie. Go across the case, people versus Jacob Huey.
Good morning, Your Honor. Ashley Plazas on behalf of Mr. Huey. Go ahead and say your full name.
Jacob Huey.
Thank you, sir. And you're looking for additional discovery. You need to do it.
I have discovered that I'll have to provide to this camera as well.
Oh, okay, so you're looking to, okay, got it. Get that all done 2 weeks? Is that what?
Would the October 3rd date be okay? I'm in trial on the 26th. Okay.
So now she's picking dates. Great. Hold on a second.
There's two green forms because I think Mr. Feaster didn't want them.
So Feaster filled one out?
PD was original.
I was originally on the case, Judge.
I gave him the vote.
I'm glad we still off.
Should have taken this form. That's the one I was reading off of. That's why I didn't understand what they said. Hers is actually filled. I get it now. No, it's your fault, Feaster. Yeah, we can do the October 3rd date as soon as we find out paperwork. Probable cause adjourned October 3rd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the people versus Dane Jones.
Good morning, Your Honor. Omar here by calendar P for the mutual hearing on behalf of Mr. Jones. Was not present because I believe he thought this would be a Zoom, Your Honor. There's a very real possibility that he is. That's my intro music, Judge.
Good job, Daddy. So where is he?
So my understanding, Your Honor, is that Mr. Jones is present on Zoom right now. His understanding was, I believe, he says that the court told him it was via Zoom. We confirmed that it was in person. We are requesting an adjournment today, Judge, regardless.
Where is he?
I've been asking the same questions, you know, that
Okay, he's not in Zoom.
He's not. So we've been trying to get in contact with him. We've been reaching out to his parents. It's going right to voicemail, but regardless, we are asking for an adjournment.
I understand that you're asking for an adjournment, and I'll deny that request for an adjournment. A bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Understood. Thank you.
Thank you. Feaster? Mr. Feaster? Did you ask Mr. Gaddy about that music?
Yes, sir.
Okay, what did he say?
That was the lawyer. That's the thing.
Yeah, okay, all right, just checking. Court calls the case, people versus Brian Haney.
Assistant Public Defender David Lee, on behalf of Mr. Haney, who appears to my right. Mr. Haney, can you please state your name for the record?
Brian Haney. Thank you. All right, what are we doing?
Your Honor, I am going to be asking for an adjournment past September 16th on this date.
Did you
Due
get
to
that?
the fact that Mr. Haney has an open case before Judge Rush Hour and he's still fighting in order to see what's going on. What we're going to do in this case, we'd like to have some further on that case first.
And the other issue, Your Honor, that my understanding is there's another right now, Judge Rush Hour to provide alcohol test.
To failure to,
Testing. Testing more around the Judge Rush Hour support. He's missed a number of tests.
Mr. Allen.
That is our understanding as well. I was able to go over the violation allegation, with Mr. Haney. He understands that he likely be remanded today.
He has an active warrant on a Judge Freshour's court. And then he's got, okay.
And I will say, Your Honor, or just for the record briefly, that the testing that he has missed, he advises is just due to his inability to pay for the test, not that he intentionally missed because he's afraid of any sort of positive test. He's having a difficult time straightening up the money for those.
All right.
But the one test that he did do was negative.
So what did you want me to do on this case?
On this case, we were just asking him to just.
But you said pass.
September 16th.
All right. Did you fill out a form on that? Just fill it out afterwards. I'll give you a date after. You said it's after September 16th?
Correct.
Then let's do September 26, 2024, 9 a.m. On this matter, I'll just have his bond continue because I'm not sure what's going to happen, but we'll figure something else out on that. But defendant is remanded in custody on the other warrant.
Thank you, Your Honor.
Thank you. Court calls case People versus Tamara Haslin.
Ready to work on the assistant public defender. Ms. Haslin, please state your name for the record.
Tamara.
Thank you.
Thank you, Judge. I think we have a resolution in this matter. I intended that court.
So I have a green form saying that you want an
We
adjournment.
did adjourn it. Was Ms. Haslin online? Spoken to Mr. Childers, we reached a resolution. We can move it up and after. That's okay.
No? All right, the court has been handed a plea agreement form that indicates that she's going to plead guilty to 2 charges. One of refusal to obey a traffic order, a 90-day offense, and false ID to police, also a 90-day offense. Upon her successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
May I have her sworn? You can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. First charge, the stated or the added count 2 is refusal to obey a traffic order. That's a misdemeanor punishable by up to 90 days and or a $100 fine plus court costs. You understand that?
Yeah.
The second one, or count 3, is false ID to a police officer. That's also a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yeah.
All right. Understanding all of that, do you still wish to plead guilty?
Yeah.
You sure?
I don't know, I'm not a criminal, but like, I don't take probation out of my.
I don't know what all that meant.
Like, I'm sweet home.
Hold on a second. Hold on. I don't want you pleading just to plea. All right. That's one of the reasons I have to go through what I have to go through here. If you don't want to take this plea and you want more time to think about it, I am not going to have a problem adjourning it so that you can have further consultation with either family, Mr. Feaster, whomever. So I don't want you to feel like you're rushed to do this. You understand that, young lady?
Yeah, I do want to take time.
You want to take time to think about, okay, that's fine. That's fine. I don't want you to feel rushed. So if like talk it.
I do want to go up to my dad and just let him know.
What?
I don't know. I want to tell my dad like that's what's going on. I honestly don't know. It's the same yet.
You're a daddy's girl. And you ain't told your daddy. And you were about to do this. I'm glad I stopped this. You knew you were doing wrong. You knew. Just, that was just that dad thing coming through. That just, all right. Yeah, exactly.
So that's my.
Yes, but now we'll use that one. All right. I don't mind adjourning this out. How long will it take you think to get to your dad, have a good conversation and figure out what you want to do? Right, but he's gonna want to talk to you. Let me give you 2 weeks. Doubters always think the conversation is shorter than it really is. September 26, 2024, 9 a.m. Bond will continue. All right, young lady, you're welcome. Mhm. I guess we don't need it. Form anymore. Court calls the case, People versus Desmond Hodge.
That's the land, yeah, people.
What you looking for, Mr. Hodge? Come on out. Is it Mr. Danny's desk? State your name, sir.
Devon Hodge.
Thank you. Mr. Hodge, do I wait for your attorney to get up there? When I was talking to that other young lady, I saw you nodding, saying, yeah, take the time if you're gonna give it to me, right? Okay.
Mike, the idea is just a public defender on behalf of Mr. Hodge.
All right. All right. What do we want to do on this?
Your Honor, I'd ask the court to set this matter.
All right. All discovery is complete.
Yes.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Preliminary examination in person, September 24th, 2024, 9 a.m. before Judge Prer.
Your Honor, if I be heard on a bond.
He's out.
Yeah.
Oh, okay.
On the tether issue.
Oh, okay. All right. Go ahead.
I'd like to confine my arguments strictly to the tether. Mr. Hodge is currently on a GPS tether. He resides in Redford. There's been no alleged contact with the complaint witness. He's a diesel mechanic who has to climb in and out of garbage trucks and gets very dirty. He's constantly cleaning the tether. They said, I don't think that he has very little criminal history. I think there's an old OWI and a DW last matter. Nothing assaulted. He was just requesting to be able to remove the tether from people he no contact with.
I don't need a response from the people. You can bring that up after testimony on the 24th. I'm not going to do it at this point.
Thank you, Judge.
All right. Thank you. Bond will continue. Court calls case of the People versus Jerry Jackson. Thank you, sir.
Thank you, Judge. I should have briefly your file.
I do, but that doesn't mean anything with you. Man.
I'm hoping about that this time around. If you see the offer, other people, I want to that's a little bit.
Without objection, October 3rd, 2024, 9 a.m. Bond continue. Yes, sir. Okay, so the People versus, is it Kanasia Johnson Jackson?
Jackson. I have been in contact with the prosecutor at this time with no offer, but she is open for me to continue to negotiate with her and supply me data information so it has.
October 3rd, without objection, 2024, 9 a.m. On continue. Case People versus Aaron Konwerski. Mr. Gaddy. Konwerski, is he here?
He is.
Where?
Captain, I don't know if he's one of the unnamed ones.
Konwerski? Well, I got one unnamed, right? No, I got two. Konwerski? Did you expect him by Zoom? We did not.
We did not, Judge.
There's a committee correction.
Congratulations.
Yeah, we have reached out to him, we don't have any now, both, both defender and I reached out. We have not heard from him. And that's the purpose of this.
Bench warrant will issue. Done, 10,000.
Thank you.
Cash surety, that warrant will issue immediately.
Thank you, Judge.
Court calls case of the People versus David Korlewski.
And your children is bringing up that.
Assistant Public Defender can applicant hearing on behalf of Mr. Lewis. Please give the record.
Thank you. I have a plea form. Is that what we're doing?
That's correct.
All right. Plea form indicates that the defendant will be pleading guilty to illegal entry without the owner's permission, a 90-day misdemeanor. Upon a successful guilty plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement. They haven't sworn.
You solemnly swear the firm testimony about to give the truth, the whole truth,
All right, so it is this court's understanding that you're going to plead guilty to the charge of illegal entry or entry without owner's permission.
Yes, sir.
That's a misdemeanor punishable by up to 90 days jail, $100, actually a $500 fine plus court costs. You understand that, sir?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
This is the only relevance.
He's on bond, Your Honor.
Yeah, okay.
We'll make sure the-
You're not under the jurisdiction of any other court. Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will? And because you believe that you're guilty of this offense, sir?
Yes, sir.
July 23rd, 2024, at the location of 1208 East University, City of Ann Arbor, Washington County, State of Michigan. What'd you do at that time that makes you think that you're guilty?
I entered a residence that wasn't mine.
Okay, and you didn't have the owner's permission to do so?
No.
And you entered that dwelling or that place intentionally?
Yes.
All right. Counsel?
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
October 3rd at 1:30 before Judge Valvo.
October 3rd, 2024, 1:30 before Judge Valvo. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls case of the people versus Devon Lee.
Assistant Prosecutor Sam, what, yeah, Devon Lee.
You're requesting another adjournment.
Yes, Your Honor, it's just a video of Mr. Lee and I would like to review and have several times.
Not objection, probable cause, October 3rd, 2024. 9 a.m. Yes.
That's the day of my, birthday, she had passed away, but.
I got you. October 10th, 2024, 9 a.m. Not a problem. Fine, continue. Court calls case, people versus Marquise Maddox.
Assistant Public Defender on behalf of Mr. Maddox is approaching. Mr. Maddox, you stand here for the record.
I'm doing great. What are we doing?
After set the matter for preliminary examination.
All discovery is complete.
My honor.
People have their witnesses available the 24th.
Your Honor, the victim is present in the courtroom. She needs a few weeks to let police let work fail, so she can have time off. So requesting to go 1 or 2 weeks past that would be best for us.
Any objection?
None, Your Honor.
So let's see. She needs time. Will October 8th work for you? Preliminary examination will be October 8th, 2024, 9 a.m. before Judge Burke. Bound with its conditions will continue. Thank you.
Thank you, Your Honor.
Court calls the case people versus Jared Marks.
Hello, Water Assistant Public Defender on behalf of Mr. Marks. Yes, all right, Mr. Marks, you state your name for the record, please.
Yeah, Mark.
Thank you. All right, what do we do?
Set the matter for preliminary examination.
Discovery is complete.
To my knowledge.
Witnesses available by the 20 or 24th.
Yes.
Preliminary examination in person, September 24th, 2024, 9 a.m. before Judge Washington. Bond will continue. Thank you, sir. Court calls case of people versus Anthony Miller.
Sound like we have Anthony Miller. I have backed down at Mr. Miller with success. I'd be asking questions.
There's also a violation report regarding.
Your Honor, on the benchmark committee set the bond at 50,000 according to the agreement that Strickland was set as a tax bond.
As a what?
That she needs a 50,000 euro.
Oh. What is it? Well, I think I'll follow my normal structure on this. I will. Bench warrant will issue for defendant's failure to appear. I'll set it at $25,000 cash. Warrant will issue immediately. Court calls case people versus Lorenzo Patterson.
Hello, Water Assistant Public Defender, standing in for the much better looking Mike Gaddy on behalf of Mr. Patterson.
How you doing? State your name for me. Thank you. All right, what are we doing?
Aaron, that's been asking for an adjournment. It's my understanding that the applications made to mental health court, Mr. Patterson has some questions for Mr. Gaddy, and that conversation is likely to take a little while.
No, I think there was also some clerical issue where the form wasn't set. I don't know if you refer this on.
I have a form in front of me now.
Okay.
It looks like it was signed up, like everything happened today.
Okay,
So-
so they did submit a new form, great.
Right, I think
Okay.
your signature was from 7/8. And then
Still
that's,
good. It's the same thing.
yeah,
Can't read it that we can.
can't read it now, right? Okay. So what I will do is give that time to happen. I'll adjourn this out October 10th, 2024, 9 a.m. All right? All right. Thank you, sir. Court calls the case of the people versus Damonte Philpot. Yeah.
Kind of over what our assistant public defender has got, Mr. Philpot.
Philpot, can you state your name, please?
Yes, sir. Damonte Philpot.
Thank you. All right, what are we doing?
Your Honor, we asked me to set this matter for preliminary examination. I would ask that it be pushed out a little farther than the date for clean giving, just to give Mr. Philpot some time to make arrangements to get here.
From where?
I think there's also, you reside in Ann Arbor, Mr. Philpot?
Yes.
So if he starts walking now, he'll be here by the 24th.
Well, he's also gainfully employed, I believe, Your Honor, so there's just a couple issues. I also would appreciate a little extra time to meet with him prior to the preliminary exam.
Which day? First.
Yeah.
Would people have their witnesses available the first?
October 1st.
Yes. All right. Preliminary examination, October 1st, 2024, 9 a.m. That's before Judge Perry. And will continue.
Is that at this court?
Pardon?
Is that at this court, the court that y'all at now?
Yes, that will be at the service center.
Okay. Okay.
Okay?
Yes, sir.
Thank you.
All that just needs to be.
Okay. All right. Court recalls the case of the people versus Federico.
Thanks, Karen, on behalf of people.
Good afternoon, Your Honor. Senator Burke, with my Mr. Federico, thank you. All right.
Okay, go ahead. Thank you.
Judge, I looked at these text messages, and unfortunately, it is what it is. It does look like there may have been some contact. It does issue some apologies in there for what it's worth, and it's not otherwise terribly intimidating, but I understand that violation of contact order, Your Honor. So hoping for just a 1 week adjournment to the court decides that
His bond is revoked. Given that. And I'll adjourn it out 1 week. Probable cause conference, September 19th, 2024, 9 a.m. Thank you. Dane. You get heard which ones I need to stop. So that got it. Got it. So these need. Here we go. Court recalls case, People versus Stephen Henson.
That's a lot of people.
This is public synergy on behalf of the chair, so we'll stop this.
And you asked that this be recalled. You wish me to cancel the preliminary examination and refer for forensic evaluation.
That is correct. Prosecution facility.
Forensic evaluation is ordered. I've signed that order. I'll set a competency hearing for December 5th, 2024, 9 a.m. His bond will continue. Thank you.
Sue you all.
Okay.
Thank you, Your Honor.
So I think that's all my paperwork, and then you got to get set up for the next block. I'll let you do that. I think those informations need to be signed on those. Who did? Nicole Hughes left. She after, oh, so somebody can sign off. But Hughes left after she called me ugly? Or before? Okay, fine. That's okay. Now I'm gonna go back and sulk now. All right. Court's in recess.
Good to see you. County, Washington, State of Michigan is now back in session. The Honorable Judge David.
You may be seated. My splendor and beauty. Court calls the case. People versus Zavan Priester.
I have Mr. Jerome Barney.
He's been around all day.
Yes, he has. Your name, young man? Thank you. I know, I saw your attorney. He was, oh, there he is.
Good afternoon, Your Honor. This is court.
All right. All right, very good. All right. And I have signed the substitution of attorney, and what do we need to do on this?
We're asking for time to discuss this matter with the prosecutor. See if we can come up with a resolution.
All right. October 3rd, that'd be a good adjourn date. Will that work? All right. October 3rd, 2024, 9 a.m. Bond will continue. Seeing you, sir. Case, People versus Matthew Schaefer.
Jessica Blanchard here with the other people.
Sanford, second time, having to check.
How much time are you gonna need to review discovery? How much time?
2 weeks.
Probable cause conference will be adjourned to September 26, 2024. 9 a.m. bond continued. Thank you. You too. Court calls case, People versus Caitlin Wilson.
Who's approaching for the record, the defendant first to go by Cameron Wilson and uses the
Cameron?
Cameron, and uses the number. Thank you.
All right.
We are requesting that this be sent this matter for preliminary examination. Oh,
Yes, I-
thank you.
You want it to, it's okay, you're good. Set for prelim.
Yes, Your Honor.
So discovery is complete. And would the people have their witnesses available the 24th?
It's fine.
Oh, might have an issue. Oh, you gotta keep your hands out of your pockets.
Yep.
Yeah, you
I'm
never,
sorry. She had indicated it was her grandmother's birthday. I was trying to find out if that was something terrible. Or, is that, or is there some special time? Yes, there is.
all day. All day. Pardon? You take her to Kalamazoo?
Any date that you said, we understand. That was a consideration.
Make it October 1st, 2024. 9 a.m. before judge. Fresh hour. Court calls case People versus Tanya Putnam. Stay here. That's probably the no.
Your Honor, I did submit I was just recently appointed, I submitted a request for an adjournment.
Mm-hmm.
I know that it has a-
Yeah, it probably isn't. I checked that box denied. How are you today? I know, that's the first time I've had to do it ever. No, consider it something special for you. Ventura. Ventura will issue bond 10,000. Cash surety, that warrant will issue immediately. Thank you. Okay, that's not true. It wasn't the first time, but just the fact it was you, it felt better than the others. Court calls the case of the People versus Jans or Johann Spiller Huffman.
And her is going to be. I don't think it's going to be because there's still.
State your name.
Thank you. We're asking for a preliminary examination.
All discovery is complete. Every witness is available the 24th.
Yes, sir.
Preliminary examination in person. September 24th, 2024, 9 a.m. before judge. I'm sorry, bar. Okay, it's a cough, right? You said. And we'll continue. Thank you. Court calls case People versus Douglas Redland.
Mr. Redland, please state your name.
Douglas Redland.
Thank you, Judge.
You're still requesting discovery.
Yes, Judge.
And how much longer will that take?
Well, not from the people, Judge. We're requesting discovery of a video from the scene of the incident. We hope to have it in the next week or two. Ready to go, Judge.
Without objection, probable cause conference, October 3rd, 2024, 9 a.m. Bond continues.
Thank you.
Thank you, sir.
I hope you feel better soon, Judge.
Yes, sir. The court calls the case of the People versus Brandon Rutland.
The public defender, Hannah Apple, appearing on behalf of Mr. Rutland.
Oh, there he is. Mr. Rutland, can you state your name, please?
Yes, Brandon DeAndre Rutland.
You need time to review video.
Yes, video and initial discovery. of electronic
Conference, September 29th, 2020. Yes. No, 26. Where that came from. September 26, 2024, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
Thank you. Courthouse case People versus Ryan Scarcliffe.
Global Water Assistant Public Defender on behalf of the defendant. Ryan Scarlett, Your Honor. Thank you.
Thank you. I have a plea form in front of me. Is that what we're doing?
That is correct.
All right. It indicates that the defendant will be pleading guilty to the charge of attempted possession of a loaded firearm in a vehicle, that being an added count 3. That's a 1-year offense. Upon the successful plea to that charge, counts 1 and 2 would be dismissed. There's further agreement, no delayed or deferred. And there's a sentencing agreement to no upfront jail, although it's my case, I'm not agreeing to that. I understand that that might be the agreement of counsel. All right. That's the court's full understanding. Is that correct, counsel?
That is correct.
All right, may I have him sworn?
You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Ryan Scarlett.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a vehicle.
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, plus mandatory forfeiture of the firearm or device. You understand that?
Yes, Your Honor.
All right. Understanding all that, still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. Copy on the photo. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
Like they just said, March 25th, 2024, at the location of Hogback Road near Clark, Pittsfield Township, Washington County, State of Michigan. Were you in a motor vehicle?
Yes,
And did you have a handgun in that vehicle?
I did.
And was that handgun loaded?
Yes.
All right. And do you have any authority, legal authority, by which to carry that firearm in that vehicle in that fashion?
No, Your Honor.
All right, counsel, have I complied with the court rule?
Expense assessment.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1401 probation. Sentencing will be
At 9 a.m.
October 9th, 2024, 9 a.m. before me. Bond will continue. All right, sir. Thank you. And you can stop down on your way out on your left-hand side. You can stop down by probation and you can set your appointment, get it all started.
Thank you.
Thank you, sir. Courthouse case, People versus Michael Smith.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Smith, who's going to be out soon.
I do see a name. Michael Smith.
Yes, sir. I'm here.
All right, need a camera.
I know I'm trying to figure out how to turn it on, Your Honor. I've never done this
The
on my
video
phone.
thing with the red line, push it.
I'm
gonna let you go, Mr. Smith. Focus on the hearing, call back.
Okay, all right. I'm working on it. Hello? Hello?
Who's that?
You.
There he is.
Oh,
Okay, you
I'm
did
here.
it.
Sorry, Your Honor.
No, it's okay. You did it.
I did it. I'm not dressed properly for your courtroom. I know that. I'm at work.
All right.
I know
All
how
right.
you feel about that kind of stuff. All right.
All right,
I'm
what are we
ready.
doing? Yes, sir.
It is my understanding that the people are going to move to dismiss this matter today. Mr. Smith had a related matter out of Monroe County that he has pled to it as a resolution on this. Discuss.
So I have your correspondence.
I didn't know that.
Yeah, I'd ask for it. I have an email correspondence that he planned, but I haven't, but not from the Monroe prosecutor.
Oh.
If we want to pass this, if there's someone wants to print out an ROA or something like that, but I want to make sure. I didn't know. I didn't have.
No, that's okay.
That's my apology.
No, that's okay. We just don't have, that is the arrangement. It's just that we don't have confirmation from the prosecutor's office.
Actually, the easiest thing, what I would suggest, is set this out a few weeks. I'll verify it if that's in fact the case.
Okay.
Thank you, sir.
All right, Mr. Smith,
Yes, sir.
did you hear all of that?
You're setting it aside for a minute or?
Well, what I'm gonna do is I'm gonna adjourn it out a couple weeks. Let them make sure the paperwork's in place. Then they're gonna submit, if has been done, they'll submit what's really a dismissal to the court, and you don't have to come back and try to figure out how to work that camera.
Thank
Did
you.
that work for you?
Yes, sir. I appreciate you. Thanks, Hannah.
All right.
You're welcome. I'll follow up with you, Mr. Smith.
All right. Probable cause conference, September 26, 2024, 9 a.m. All right. Thank you.
Have a great
Mr. Smith,
day.
have a great day, sir.
All right. All right, you too.
Case of the people versus Joshua. Is it Steinke?
That's the money for the people.
Working for police to assist the public defender on behalf of this matter. Mr. Stockton, please turn on your camera and state your name for the record.
Trying to get him to him. He's a Don farm.
Oh, is it? Okay.
Please call our judge. That might not seek an adjournment.
But he is at Don Farm.
Yeah.
All right, rather than wait for him. I see him on the screen. October 3rd, 2024, 9 a.m.
Thank you, Judge.
If you can message him to let him know, he might have had to pull away for.
Thank you, Judge.
Thank you. Court calls the case, people versus Nicholas Strunk.
And Jessica Blanche Karen on the other people.
Your name?
I apologize, I did not know we were going to see Mr. Strunk today. I wasn't able to reach him prior to today's date. I would be asking for adjournment. I will submit an order to that effect.
We have one.
Oh, well, then good. Yes, I was on it.
October 3rd, 2024, 9 a.m. Continue.
Yesterday.
October 3rd.
Thank you very much.
Court calls the case, people versus Devon Tatum.
Hello, Water Assistant Public Defender on behalf of Mr. Tatum, should be present by Zoom.
I'm here.
State your name then, sir.
Devon Tatum.
Damonte. All right, what are we doing?
I'll be asking to adjourn the probable cause conference.
Did we get a form on
This matter, court entered an order allowing him to pay some restitution up front. Though Mr. Tate is going through a divorce proceeding right now, and that has had a negative impact on his finances. He believes he can make that payment within a month.
October 10th, 2024, 9 a.m. Bond continued.
Thank you, sir.
Thank you.
Thank you. Court calls case People versus Adriana Taylor Hamby.
Andrew, for the grant, yeah, people, Assistant Public Defender Jay Belcher on behalf of this, Taylor City.
Hello. How are you? Thank you. All right, what are we doing?
We were just planning on setting this primary target. Discovery.
And with the people had their witnesses available the 24th.
Yes.
Preliminary examination in person will be set September 24th, 2024, 9 a.m. before Judge Washington. Bond will continue.
Thank you.
Thank you. Thank you, ma'am. Court calls the case of the People versus Colin, is it Vandermeer?
Andrew, so there's going to be a people.
I was able to locate him. He's like not in that facility, but it goes straight to voicemail.
Is he in a facility?
Well, I'm not able to locate him. I do see that he was found incompetent by historical. I believe.
Yes, but. Well, fine, here's what I'll do. I'll adjourn the hearing out. See if you can locate where he is rather than issue a bench warrant. So I'll do an October 10th, 2024, 9 a.m. day.
Thank you.
Court calls case People versus, is it Ukesha Vincent?
Just a minute, Prer, I get people.
Oh, there you are. Okay. I was looking on the screen.
Assistant Public Defender Jay Belcher on behalf of Keisha Benson, Your Honor.
Your name? Thank you. What are we doing?
We're just setting for a time as well today, Your Honor.
All discovery is complete. People had their witnesses available the 24th. Preliminary examination in person, September 24th, 2024, 9 a.m. before Judge Barr. Bond will continue. Thank you. Good for that block?
Yeah.
Then I have my 2 o'clock and then 3 o'clock and then I'm good. All right. Let's go stand in recess. Thank you.
All right.
Then I'm
Thank you.
14A District Court for County of Washington, State of Michigan.
That's a bit rough. You may be seated.
The first case requires your interpreter.
Yes.
Good afternoon, Madam Interpreter. Can you please turn on your camera and unmute? Afternoon. You're before the Judge J. Cedric Simpson out of the 14A1 District Court. Can you please raise your right hand and sworn? You solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, translate from English into Arabic and from Arabic into English in the manner now before the court, so help you God.
Yes, I do.
And good afternoon, Madam Interpreter.
Good afternoon, Your Honor.
Court does call the case People of the State of Michigan versus Al Amari. Is it Selah?
المحكمة تنادي قضية العامري.
Image Ganatra for the people.
Good afternoon, Amir Macklin.
Madam Interpreter, that would be Nimish Ganatra for the people.
نمش جناترا هذا هو الادعاء العام.
Good afternoon, Amir Macklin for the defense.
إذا عامر مقلد اللي يمثل محامي الدفاع.
Your name, sir?
اسمك
ماجد
ماجد العامري.
The court has before it a plea form that indicates the defendant will be pleading guilty to the charge of use of a controlled substance.
يوجد أمام المحكمة اتفاق بأنه المدعي عليه سوف يمثل أمام المحكمة بأنه مذنب إن استعمال مواد محظورة.
That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs.
هذه تعتبر جنحة. عقوبتها قد تكون مدة أقصاها سنة في السجن وغرامة مالية $1000 زائدا تكاليف ورسوم المحكمة.
Upon a successful plea to that charge, count 1 would be dismissed.
إذا كملنا هذا الإقرار بهذه التهمة فإن التهمة الأولى والأصلية سوف يتم إسقاطها.
The form further indicates that there is no objection to 7411 if otherwise eligible.
كذلك الاتفاق بالورقة يقول إنه ماكو أي اعتراض على الاستمارة رقم 7411 إذا استطعنا استعمالها.
Is that's the court's full understanding of the agreement? Is that correct, counsel?
حضرة المحامي هذه هي فهم المحكمة. هل هذا بالنسبة لكم نفس الشيء؟
Yes.
Yes.
نعم.
Can't hear anything.
Good morning, good afternoon, Your Honor.
Good afternoon, Your Honor.
Ryan Murad, P83665, on behalf of Mr. Fareed Hajar, who's sitting presently to my left in my office. Mr. Hajar, please state your name for the record. Fareed Hajar.
Good morning, Your Honor. Mark Krieger, also on behalf of Mr. Hajar.
Good, I guess afternoon or morning. All right. And what are we doing on this case today?
We are setting it for preliminary examination. I received an email from Ms. Blant that she expects the autopsy to be completed by the end of this month. And she would like to, that she wants to introduced perhaps the autopsy at the preliminary exam and asked if we would agree to a date in October, and that is fine. She said the only date she is not available is October 22nd.
Okay.
So,
I could do October 8th.
I may be on vacation. Can we do the following? What do you do them on Tuesdays and Thursdays, Your Honor? Although this is in Chelsea, I believe.
No, it's not in Chelsea. It's gonna be before me.
Oh, it
but
is.
I guess gotta get you a date. You said you're gone the last,
22nd, is that Tuesday, second, I thought you'd be saying on a Tuesday, the 22nd, I am,
20, okay,
and
that's
the
fine.
but the 29th or the 28th, I started jury trial, so that going to 29th. If you're keeping it before your honor, the 21st, can we do it on a Monday?
I will, I mean, just to get it. Do I have the 21st?
We have jury, it's jury selection, so I don't know. Either one's.
How long, how much time do you think you guys need for this? A whole day?
I would think a half day.
Half day? So if I set it in the afternoon on the 21st, will that work?
That works.
I have a dental appointment at 4, but if we can finish by 3, I'll be fine. The dental appointment.
Well, that usually is dependent on you guys.
I guess if we don't finish, we could continue it another day, Your Honor. So you want to, what time would you be?
Yeah,
able
I
to-
can set it on the 21st, and if we have to go to another date, I can get you another date. How about that?
Sure. And what time would you like that, Your Honor? 1 o'clock?
We probably should do 1. 12? Yeah, because we should, all right, 12 o'clock. So I'll set preliminary examination in person. What did I say, October 21st, 2024 at 12 noon. And that's before me.
And I can stay till 3:30 without a problem, Your Honor.
Okay, all right, just remind me and we'll get you on your way for sure, okay?
Your
All
Honor,
right,
Judge,
Yes, sir.
I can definitely make the 21st work, but is the 28th available by any chance?
I don't think for the prosecutor because she has a jury trial starting.
The 28th works for me as well, Your Honor.
Then just go ahead and set that, I just won't. No,
I'm gonna set it on the 21st. This time, if we gotta go to another date, we'll figure it out, folks. All right?
Thank you, Your Honor.
Thank you. Bond continue.
Thank you.
Thank you.
Thank you.
Court calls the case, People versus Jeff Meyer.
Good
afternoon, Judge Eric Langton on behalf of Jeff Meyer. I do believe he's present via Zoom.
Mr. Meyer, can you state your name, please?
Jeff Meyer.
Okay, you're requesting an adjournment, and counsel, this was the one that got emailed over to us?
Yeah.
He should teach our people how to do this. Thank you for doing this for him, getting it over to us. We do
Yes, Judge.
appreciate it.
I was not sure if that applied to the Zoom participants as well, but
It really does, but you know, thank you for taking the proactive route of actually doing it. I appreciate it.
I do apologize that it's not on green paper, Your Honor.
No, when we printed it, we got it on green.
Oh, there we go. So it is on green
So
paper.
we took care of that for you. All right.
I think I'm gonna have to go out and buy some green paper though, just in case.
No, don't bother doing that. We got him here. Okay. How much time did we need on this for further negotiations and the like?
Judge, I think 2 weeks would be sufficient. I have been in negotiations with the prosecutor's office. There hasn't been any type of firm offer yet. I think both myself and the APA assigned are looking to try and make contact with the victim. The victim is 15, which does make it difficult. So I think 2 weeks should be sufficient, Your Honor.
You think 26th or the 3rd, which would be your preference?
The 3rd would be my preference, Judge.
All right, let's do that then. October 3rd, 2024, 9 a.m. Bond continued.
Thank you, Judge.
All right, thank you. Thank you, Mr. Mayor. The case of People versus Alexis Perry.
Sharon.
Your Honor, did you call Alexis Perry? I'm sorry.
Yes, I did, sir.
Yes, good afternoon, Your Honor. Attorney Samuel Bennett appearing with and on behalf of Ms. Perry, who's appearing by Zoom as am I.
All right, Ms. Perry, can you state your name, please?
Alexis Perry.
All right, what are we doing today?
Your Honor, I've been in communication with Ms. Hughes, who's not in your court today, but Mr. Childers knows what's going on. There's just a few other things we have to work out on this case, so we're just asking for a few weeks adjournment so that we can get that accomplished.
October 3rd, 2024, 9 a.m. Bond continued.
Thank you so much, Your Honor. Have a great day.
Okay, you too.
Thank you. Take care, Mr. Childers.
Court calls the case People versus Antonio Cherry.
And good afternoon, Your Honor. Reading on P 44626, appearing on behalf of Mr. Antonio Cherry, who should be present by Zoom.
Cherry, can you state your name, please? You have to unmute.
Antonio Cherry.
There you go. All right, we got him. All right, what are we doing today?
Judge requesting a preliminary examination, please.
Sorry, I didn't hear that last part.
Requesting a preliminary examination date, please.
All right. Discovery is complete.
To my knowledge, it is, Your Honor.
And would the people have their witnesses available the 24th?
Judge, I'll be in trial on the 24th of September. Sorry.
No, it's okay. What about October 8th?
Would that be an afternoon hearing date?
No, they're always in the morning.
I have a motion hearing at 9 a.m. Can it be set for 11?
What about the 1st? Am I on the right date?
Of October, let's see.
Pardon?
That's great, Your Honor. October 1st at 9 a.m. is great.
All right.
October 1st at 9 a.m.
Preliminary examination, October 1st, 2024, 9 a.m. before Judge Perry.
Okay, thank you so very much, Your Honor. Continue.
Thank you. Bond continued.
Have a wonderful day.
You too. Okay, so
I'll be in touch, Mr. Chair. You can still.
all right, I should step off for a moment. And then we've got. Thank you, sir. And then I got those two, and I'm gonna take a brief break and then I'll come right back. Court stands in recess.
I would say ordinarily you would be waiving the right to an appeal, but because this is being heard by me as the magistrate, then my decision may be appealed within 7 days. Okay, so once I have made the decision, If that happens today, it would be 7 days from today. You can file an appeal and the case will be heard again by Judge Washington, the district court judge here. Okay, so do you have any questions? Do you both understand all that?
Yes.
Okay, and do either of you want to remove this case to the general civil docket?
I do not.
No.
Okay, thank you. Then the way that this is going to go, as I said, I am going to swear in both of you. Ms. Grant, because you are the plaintiff.
Sorry, I'm popping in on the side because I'm just gonna try find. I didn't want to watch this one. I wanted to watch. Oh, I'm getting myself double. Okay.
Versus Patricia Robinson, case number 24C 1841.
Good afternoon, Your Honor. Michael Bankstein, P 69778, on behalf of Absolute Resolutions Corporation.
Good afternoon, Mr. Bankstein. Ms. Robinson, please state your name.
Yes, hi, this is Patricia Robinson.
Thank you. Good afternoon.
Good afternoon.
We're here for a pretrial as well as a motion for summary disposition today. Ms. Robinson, have you received the motion for summary disposition?
The motion for summary, yes, I have.
All right. Do you understand what that is, ma'am?
I understand from what I've read. I didn't read the
What is
entire
it that
thing.
you think you understand?
What is it that I don't understand about
What
it?
is it that you think you understand, ma'am?
That it says here, the plaintiff Absolute Investment LLC, here and after the plaintiff
Okay.
has filed.
All right,
a
never mind. Let me tell you what this all means, okay? They filed a motion today, basically saying that you lose, that you don't have a defense to this action, and that they want to get a judgment against you today. That's what that all means. Okay?
Oh, that was without me? You guys
That's
met
what
without
that
me?
means, ma'am. That is what that means.
Okay.
And you had an obligation to file a response to that within a certain time period, which you
I
did
did
not.
file a response.
When did you file your response, ma'am?
I did.
When did you file a response to their motion for summary disposition?
I filed a response June the 21st.
And this was filed on August.
Your Honor, I may be of assistance. Defendants frequently mistake the answer and a response. The answer to the complaint was filed, but we've received no response to our motion for summary disposition.
I wasn't aware I was supposed to respond a second time. It didn't say like the
Respond
first
to
time.
everything. Well, that's the reason. That's the problem with trying to represent yourself, ma'am, is that people don't understand the court rules. The court rules provide that you have to respond within a certain number of days to a motion for summary disposition, and you didn't do that.
Well, the first one was clear. The first one was very clear that I had.
I'm not here to argue about the clarity of this or what the laws are. I'm just telling you what it is.
So what was I supposed to respond
I can't
to?
give you legal advice to the motion for summary disposition. I've said that like 3 times.
Okay, it doesn't say here that I'm supposed to respond within a certain amount of
Ma'am,
time.
one more time. You are, as a person representing yourself, supposed to respond based on the court rules, and no one can give you legal advice about that. That is what you're supposed to do. You're held to the same standard as a lawyer when you don't have one. So that's why I'm trying to explain to you what that document is so you can fully understand the position you're in. I'm not here to argue with you about it. I'm trying to explain it to you.
Okay, I appreciate that.
So, knowing the position you're in here today to the motion for summary disposition, do you want to talk to them about trying to reach some type of resolution on this issue, or what do you want to do? What is your position to the motion?
What is my position? I am not indebted to this company. I don't know who they are. And that's what I was talking about. I don't have an account with them, or they created a fraudulent account. They said on the second page of the motion, that's what I thought I was responding to the letter today. That
Not a letter, ma'am, it's a motion.
On the motion. And I thought I was responding today to talk about what I'm reading here. And so, it said that the account was used, and I don't see any evidence of that. It said that there was activity. I don't see any activity.
And that's all, they provided you with statements. Do you not see the statements?
Yeah, but it says activity. That would be some purposes.
That's activity, ma'am. The statements show you the activity.
Yeah, but there's no purchases.
There's no what?
Purchases. A purchase is an activity. Did you see that? Like on any of the statements, a purchase is an activity. They said that this account was used. I didn't use it. It says activities, and to not just that, I'm not indebted to this company. I don't know who.
Which one is your defense, ma'am? I need one or the other. Are you saying you didn't make a balance transfer of $416 on this account back in June of 2021, and a balance transfer of $4,340? Are you saying you didn't do those things, or are you saying that it's not you? I'm not sure which one.
What I'm saying is that I'm being sued by.
Ma'am, I know who you're being sued by. Please answer my question.
And I am not indebted to them. No, I don't owe them anything.
So are you saying this? Okay.
I don't owe absolute anything. I don't have an agreement. I don't have a contract. I don't see anything with my signature on it.
All right, thank you. Mr. Bengstein?
Thank you. Again, our office did not receive a response from defendant to our motion for summary disposition. Without belaboring all the points in the brief in support of our motion, I do want to bring up a few highlights. Defendant opened the account, made purchases and payments, then stopped paying on the account.
She said she did not, so I want you to address that. She's saying
that's part of it. There's more than just one sentence. It's going to be a comprehensive response. Defendant opened the account, made purchases and payments, stopped paying on the account. Those statements went to her address, never objected to the statements. There was activity on those statements. There's payments being made. A payment is an activity also. I'm not clear on why somebody would make multiple payments on an account that they also say they don't owe on. It does appear that defendant is making some sort of privity of contract argument. I noticed she very carefully words it, I don't owe Absolute Resolutions Corporation. Absolute Resolutions Corporation was not the originator. But we have attached documents that show the chain of title. Privity of contract was a great argument about 120 years ago, but that's not the rule anymore. This stuff is fungible. If you have a contract with somebody, that someone can sell the paper to someone else. And that's what's happened here. Defendant has not demonstrated that there's any material issue of fact in dispute, and plaintiff is entitled to judgment.
You use a lot of big words that I'm sure she doesn't understand many of them. What do you mean by?
But I understood one thing, Your Honor.
Ma'am, please don't talk over me. Ma'am, please don't talk over me.
Oh, I'm so sorry.
Mr. Bengstein, when you say privity of contract, what are you saying, sir?
Well, it's right in her answer. I'm basically just, let me pull the answer up. I'm just, presumably she understands what she put in her answer. So I'll pull the answer up. Give me a second. Just scrolling down.
The assignment of the debt?
I'm just scrolling down to the answer. I'm just trying to address the points that she's brought up. Give me 1 second. I think I'm just about a page away from it. Let's see. No paperwork that's in her name showing assignment of a debt. There wouldn't be anything that she would have signed. we do have a letter from the originator saying, hey, we've sold your debt to these people. And we have a debt from, we have a letter from Absolute Resolutions Corporation saying, hey, we're the ones who it's paid to now. I mean, that shows the assignment. She may object to the assignment. She may not like that there was an assignment, but that's not, the debtor is not required to sign off on an assignment between two companies. I mean, that's something that was sent to her. She never objected to that. It's to the same address that she has now, I believe.
And which part of your exhibits is the assignment in, Mr. Banks?
That would be Exhibit B. There's a letter from regarding her account. It does have her account number on it. It does in fact have her name on it. It does have the balance, and it says that we're going to stop accepting payments, that now it's been transferred, and you now send payment to Absolute Resolutions Investments. And then defendant also received a letter from Absolute Resolutions Corporation saying, please take notice that your U.S. Bank DBA Elan Financial Services account has been purchased and assigned to Absolute Resolutions Corporation. Again, it has the account number. Again, here's where you send the payments.
And you're talking about Exhibit B with the date of December 28, 2023, with the transferred balance of $4,343.31, correct?
That's correct, Your Honor.
Mm-hmm. All right. Anything else from you, Mr. Blankenstein?
I have nothing further other than what we've already discussed and what I put on the record, Your Honor.
All right, thank you. Ms. Robinson? Anything from
Okay,
you?
Your Honor. I'm sorry, what was that?
Is there anything from you, ma'am?
Yes. In response to what you just said in Exhibit B, and I did look at that letter, or line, the third, number 3. It says absolute.
Oh, wait 1 second.
I just can't hear what she's saying.
I muted her by accident. I was trying to stop her video so I could hear her because she was lagging, but I muted her. Can you hit on mute again, ma'am, please? I'm sorry. All right.
Okay.
I'm going to stop your video, ma'am. Thank you. Go ahead.
Okay, so the attorney said that there was a title transfer. And on number 3, it says Absolute Resolution Investments may not transfer title to your account.
Number 3 of what? I don't know what you're referring to, ma'am.
In Exhibit B that he just pointed out, that the letter, and the letter states here that they're just that this was a transfer. Your Honor, I read in 33.9.901 the article about collection agencies that they're supposed to be connected to this company somehow, the original creditor, like an employee, like they're doing this on behalf of them.
That's not true, ma'am.
May I point that out? Exactly where it's located, because I did read that today.
You can point out whatever you would choose, ma'am.
Okay. Okay, so in the definition for the occupational code, this is the Act of 299 of 1980. Under the 3.901, it says the collection agency. And I guess I don't know if he's considered an attorney or if this is considered a collection agency. But if you read down the paragraph, it says has been employed to collect. And unless this company is employed to collect, or they have some type of a title, they shouldn't be collecting from me. I am not indebted to them. There is nothing in this letter that said that a debt has been transferred. A debt. It doesn't say a debt. It says account. Account and a debt are two different things, Your Honor. That account means that there's some type of a contract of assignment that I signed between me and Absolute. And they open up an account without an agreement. And to me, that's fraudulent. So that's what I'm saying. So I am not indebted to Absolute. They're saying that I'm indebted, but it's showing that I am not indebted because there's no contract. They didn't show me any contract that I owe them anything. There's no contract that I owe Absolute.
Response to her. Go ahead.
I'm sorry, you guys were talking over each other. I missed that last bit.
I told her to go ahead.
I see no paperwork that shows that I am indebted to Absolute. And that's what I've been looking for through all the paperwork that I looked at, through all the statements that they sent. I'm seeing the original creditor in which I'm indebted to them because I signed a contract. I did not sign a contract. And this letter does not state that it just says that they transferred. It doesn't say that they gave, any type of debt that I owe this company. It says here on the letter, your new owner and servicer, Absolute Resolution Investments, will immediately start accepting payments. Who are they? There's no agreement to with this company. It's just a letter. It doesn't show that I owe any type of debt.
Right, thank you. Any response?
And unless they come up with a contract that I signed something, agreeing, some type of agreement, I don't owe Resolute. I'm done.
All right, thank you. Mr. Bankstein, any response to that?
Yes. First of all, a response and any evidence attached thereto is due by 7 days prior to the hearing. Again, defendant just, I guess, feels she doesn't need to follow the Michigan court rules. But despite that gotcha moment, I wasn't able to find the site that she was citing to the occupational code. I wasn't able to find where it says that. Also, defendant appears to be under the belief that for one company to transfer the debt to another company, that it requires her agreement, and that simply isn't the case. She got a validation notice from our office. She got the letter from Elon. She got the letter from Absolute Resolutions Corporation. Never objected to any of those letters. Never objected to the validation notice. Clearly, those are contracts. Statements that were sent to her address. Never objected to those. She made purchases and payments. There may not be purchases showing on that account, but there were payments on the account. I believe that we've more than met our burden of proof, and in the complete absence of any evidence provided by a defendant, I'm asking the court to grant our motion for summary disposition.
Thank you. The court has had an opportunity to review the motion for summary disposition in this case, listen to both the moving party and the non-moving party as to the issues before the court. This is a C9, C10 motion, and basically the court has to look at whether or not there's a defense to this claim. The defense being asserted is that the notice of assignment of the sale or transfer of ownership rights was not proper because the actual person liable for the debt didn't sign it. That is the absolute opposite of what the law is. That is not how the law works. The company that you entered into agreement to much to many people's dismay, have the right and the opportunity to make that assignment. That notice was sent to her that it was assigned. It was sent out on December 28th, 2023. It looks like the parties read into the record only the first page of that notice. The second page of the notice indicates that you are hereby notified that the servicing of your credit card account, that is the right to collect payments from you, is being assigned, sold, or transferred from Elan Financial Services to Absolute Resolution Investment. And clearly gave the notice that is provided under the law that needs to be provided. The motion for summary disposition is granted. I will sign an order to that effect. I have it in front of me and I'm signing it now.
Thank you, Your Honor. Have a great day.
Thank you, you too. Yes. Portfolio Recovery Associates LLC versus Nathan Klein, 23C.
Yeah. Court calls case people versus Brett Thompson. All right, I had set this, I think the record is clear. Mr. Thompson had indicated he was going for a particular reason to North Carolina. I revoked that privilege to go to North Carolina. We had one hearing, then I set this hearing off of that, and he's not here. Is that correct?
Yes, sir.
Do we have any idea whether he's in custody?
I tried to look up in Iredell County to see if he was in custody, and it doesn't show that he's in custody. I'll send further information that is, I know he had informed the court that he went to North Carolina as a family vacation because his mother passed away and he's gonna spread her ashes. And I have information that his mother passed away in 2021 from a car accident. So that's also concerning.
Yes.
He has a matter pending in North Carolina, obviously that's extremely serious, that involves guns, ammo, and a lot of drugs. So he asked that you're focused on, are you benchmarking him?
Yes.
At this point, Judge?
Any response?
No, Your Honor, I will try to see if I can figure out whether he's in custody. I actually don't have any information about that at this time.
Bench warrant will issue for defendant's failure to appear. I will set no bond at this time as bond on another matter is revoked. That warrant will issue immediately. Thank you. Court does call the case, People versus Peter Heenan. Bless you.
Jessica, please.
And may it please this honorable court, Michael Nicholas on behalf of Mr. Eden. Thanks. I have quite a few things going on.
Yes. Mr. Heenan, how are you, sir? State your name. All right. Okay, where are we now on this?
Your Honor, I picked him up at U of M about 2:15
Today?
today. I took him to his apartment so he could pack a bag. Had my eyes on him the whole time.
Yes, sir.
He is on 2 medications right now for seizure concerns because he's detoxing. Obviously, he's prepared to acknowledge that he's alcohol. He had been on the phone with Bear River. Off the record on Tuesday, we talked about that.
Yes.
And if you recall, there's an order in your file from July 3rd where you ordered CMH to bring an assessment.
Yes.
It was the issue of Mr. Heenan being private pay. And what happened was he never was assessed by Washington County CMH. He ended up going to Liberty House in Livingston County for just, I think, was it 14 days, Peter?
I believe it was 24 days.
24 days.
Too short.
So same problem still exists with Bear River. We were on the phone with them from about the time I picked him up at the hospital to his apartment in Armstrong Road. It would be about 10 to 14 days before they could get him into the bed, and he'd have to private pay. Sanford House, which is a facility in Grand Rapids where I've had clients go before. They do dual diagnosis. They would do a 90-day treatment. They'll accept his Blue Cross. They've got a bed available. We also checked with Liberty House again. They've also got a bed available. They also have dual diagnosis. We talked off the record about that as a concern. I would offer that we go into whichever one is closest and most available. And if there's any delay for whatever reason, I don't think there will be. He's got the companion service that I mentioned off the record. This is the agency. I've never done this before, never heard of it, but apparently they bring a 24-hour support person into your home to make sure you stay sober, don't engage in maladaptive behavior, and get you to where you need to be until that bed is available. It's the same thing, if not better, than the jail alternative, which has the big benefit of sobriety, but that's the only benefit. Offering, he's still wearing the scram bracelet, and he at least, got himself to the ER on Monday morning, and started detoxing. So that's where I'm at this moment. And I did provide to the court, and I think to Ms. Blanche, I think they call it the hospital audited assessment. It's kind of
Yes.
living document from the first time I went there to his arrival on Monday.
So there are beds available for him now.
At two facilities, Sanford House and Liberty House. And I listened myself to the phone calls.
Is there anything from the people on this at all?
I'm obviously just concerned based on obviously he was in custody, he was released on a scram. He had been testing positive for benzos and alcohol. Originally, he had missed tests, and that's why he was in custody. And then he got released, and I think the drug testing fell off for some reason because he was released on a scram. So now, he was withdrawn from Bresalam. He was also positive, obviously for benzos prior. So I'm just concerned. I would like the drug testing aspect to come back on if he is, that he needs to be an inpatient if he's going to be in the community. I don't know if he's driving or what's going on, but obviously if he cannot stay away, be clean, and he's on the roads or whatever, that's a huge concern. He's had a lot of, he's been violating, and he's had a lot of chances, to be honest. So I don't know. And I get it, but his case has been going on since June, and I'm just, to move this case along, I realize he needs help, but at the same time, we have a pending case of a victim here, that, would like to see the case move forward.
Right. And I realized that you were not part of what we had on Tuesday. And so I would just say this. This gentleman has a lot that's sort of happening life-wise, including, and I'll just say this, some of the things that are happening are, and I'm going to put it in my simple way, but I'll say it's really a result of the grieving process of the breakup of a family. And for him, that's been a huge piece of it. My understanding is from my notes that I had, I think he said 16, 17 years sobriety. And then it just, he's not, if I thought he was playing a game, and you know how I am, then I don't have a problem putting him in. I don't think he's playing a game. I think he may be in some ways unwittingly playing sort of a Russian roulette with his life. But I don't think he can help it. I really don't. He was in, and I understand this, Blanche, when you talk about danger to the community, but I also realized this was a gentleman who was at such desperate points that at some point he could have gone out and drove when he was having these sort of this other relapse. He could have, he didn't. It's like he knew enough not to do that, but he had then the alcohol brought to him. And so it's sort of strange because the danger wasn't really to the public. I mean, it's almost like he was conscious enough of that. The part he wasn't conscious of was the danger that he was posing to himself. And I knew that when we were here, we were supposed to be here the last time, and Mr. Heenan wasn't here, and I was getting the report. My great fear initially was we were going to find the worst. I'll be honest with you. That's what I thought. And council showed up, and I think council was worried. And when council said that I gave some time on the warrant rather than issue it right away, and council said he was going to go out and he was going to go himself. Extraordinary, in my view. Watch a lot of lawyers practice, do their craft, but that was extraordinary. By the time he got here on Tuesday or whatever day we were here, he knew where you were. He knew what they were saying about what they were going to do with you and things like that, and was trying to game plan what to do. Extraordinary. So I get all of that. I don't. We got to get him into. Just got to keep getting him to treatment. Trying. Shane, is there anything you want to say before I? Pardon?
Very sorry for letting you down. I agree.
Shane, and I appreciate you saying that. Not necessary. This job, I tell you, is a weird job. Because the happiest thing I was when I got off the bench and I was walking back and then gonna come back out. Greatest thing in the world was that I saw you. Because I didn't know. I mean, I knew counsel. I knew he was trying to do things. He's communicated with the office. But I didn't know. So there's not an apology needed. You have to just realize, sir, you're not alone. You're just not alone. And I know at times it seems that way, right? Especially in your circumstance where you don't have your family. And we had talked about that in our conversation. And I don't entirely get it, but I get part of it. But you just have to know that you're not alone in this whole thing. It's a rough journey, right? Okay. And appreciate that you're worth it. Okay? I don't think all of us would be here if you weren't worth it. As a human being and as a person, you're worth the effort. Okay? And always keep that in mind. life can look so dark sometimes, but really, if you think about it, on balance, life is grand. Right?
I know it was 16 years.
Yeah. And now we just gotta find a way to get you back there. Right? So let's walk it. Let's do it. I want you, sometimes I do stuff and I say stuff and I'm not sure why. But sometimes my gut just tells me something. I want you in the place in Grand Rapids. The one out west. That's, I understand council said someplace, but I don't know what's telling me that. But if that's where we can get you at, I'm just, that choice, I'm just gonna go with my gut on.
It's 100%.
How can we get you there? How are we gonna make that work? Now, they said that there was a bed. So how are we gonna get all that set up?
I would have to give them a call to communicate. Obviously, I'm not going to drive.
Right.
My oldest lives in Grand Rapids.
Pardon?
My oldest lives in Grand Rapids. I can make an excuse to go with that. And you know what? You don't know me, Your Honor, and neither does Ms. Clanch. My plan today was to be at Comerica Park watching Terry Google pitch. And I thought about it. I said, how many times do you get to see that? But how many times do you get to try to save a life?
That's it.
And that's what we're doing. Right?
Okay, so here's what I want. I'm not gonna lock you up. Right? I don't want to do it. I'm not gonna. You're to get enrolled, get yourself in a bed, and I want you there by tomorrow. Got it? And I trust counsel will report to both prosecutor's office and myself.
In the same fashion.
Yeah, just to give us a status of where he is and things, and when he's on his way there, and if he's in, he's in. Okay.
And then sober living after.
Absolutely.
Mr. Rosso said transitional.
Yeah, some type of, once that program's done, it's, and what we talked about. So basically you have to, the community that was supporting you before was ripped out from you. For good or for bad, I'm not here to say what the reasons are. It just was. And so you're wandering alone. Right? And so you have to sort of recreate a community for you and a community that will support you. One of the things that, I also said is, and I can bet you think you're the only one going through this, right? You think that you're and when you begin to think that, the world looks like a really lonely place, right? So we got to do this part. I mean, the idea would be to do this part. Then when you come out, transition, get into some type of transitional housing, be around people that are having the same struggle as you are, that can appreciate when you say something, they can appreciate it because they've probably been through it, and maybe stop it from occurring with you or stop that thought process from going. So that would be sort of the long-term plan of that. What do you think about that?
I completely agree. My biggest issue is I don't like to inconvenience people. And I need to get over that with sponsors and reaching out, fellowship. But I know I need it.
Do you think we're inconveniencing us right now? Do you think you are? No, you answer. Do you think you are? You're not. It's what we do, first of all. All right. And what and that's the big piece that you have to get over. You're worth it. If I have to do something for whatever I see worth in, then it's not an inconvenience. And if that's the case, you can't be an inconvenience, and you can't be inconveniencing us. You got it? So one thing that you learn about me, Mr. Haney, and anybody will tell you this, if I give you my word, I'm gonna walk that walk with you, do what I can. Some things I can't do, but if I say I'm gonna do that, I'm gonna do it. If nothing else, I'm a man of my word. So fair enough? So when you get in that mindset, particularly regarding this court, that somehow or another you're inconveniencing us or doing whatever, just almost have the trigger be for you in your head, you're worth it. Have my ugly face, as I've been told today it is. Thank you, Ms. Hughes. Remember my face telling you you're worth it. Got it? You're welcome. Thank you for being you. Thank you for showing up here. Thank you for being alive today. Because every day, Mr. Heenan, I wake up and I just hope that I get to see a miracle. Sometimes you don't even know a miracle when you see it. But what you've been on for the past couple weeks, the very fact that you walked through those doors, that's my miracle for today. Okay? So what I'm gonna do for a future date, I want him in by tomorrow. I'll just put it out 1 week, not expecting that we're gonna be able to do anything, but we'll at least have a date that's a check-in. Council, you can appear via Zoom if everything's all set. Anything else? So just set. Do I have a warrant out on him? Okay, I don't think so. So I'll set this for the 19th, 2024. I'll set it at 9, but see that I'll have his bond continue in this matter, and I will indicate defendant. It's Sanford House, right?
Sanford House.
Yeah.
Sanford Behavioral Health.
Yeah, okay. I'll get it done. All right, and we'll look for the updates. Okay, you're welcome. Gonna tell Miss Hughes what I said?
No, I was upset you didn't say that it's a miracle when I walked through the door.
I think they just ended the stream. It sometimes lags like this when the stream has ended. Let's just see.
Mindset. Anything else? So I'll just set.
Yeah, I'd say that's the end of it. So Heenan made us all cry again. I do wish he knew.
No, I was upset you didn't say that it's a miracle when I walked through the door.
Yeah, that's the end of the stream. I do wish he knew that we were all rooting for him so much, that like we've been following his journey more than anyone else in Judge Simpson's court. Let me just pause him for a sec. Sorry. Let's just make double sure. Still says live. No, that's the end. So some of the things I picked up, one, when his counsel, so one, I didn't know Judge Simpson was worried that he was no longer with us. That didn't cross my mind at the time. I presumed he had relapsed. No, Frank Green wasn't back at the end. It was the video reloading from the start. You might have missed Frank Green. Not many updates there before I go into Heenan. His update was just that it is continued for, I want to say, 27 September or something like that. It was very quick. So I didn't think of the possibility that Heenan may no longer be with us, but the judge's reaction makes sense because remember his face, like that was the thing that really upset me, was how excited he had looked to see Heenan. And then there was like a moment where he just looked not even disappointed. And that was what kind of caught my attention. The other thing was that he started detox on Monday. That means it is safe to assume he didn't show up to court because he had relapsed. So he had gone mid-August to, I think he had the tether thing on the 23rd of August, somewhere around there. And then 5th of September was his last one. And that's when he didn't show up. So he had actually relapsed. I love his lawyer. I don't think the lawyer anticipated Judge Simpson saying, like, I want him there tomorrow, because the lawyer's oldest kid is going to get a visit. That was very unexpected, very, very quickly. But I'm so glad I just Googled the place, and it's like greenery everywhere. It's a beautiful house. It's far from all of his current struggles, which means that he's out of, like, when I went to the clinic, what was really helpful is like not having to think of meals, not having to be an adult at all. Like that really helped me focus on me. And he's being completely removed from everything into this bubble, I think will really help, because what is jail, prison, what is it going to help right now? So in case you don't know, his original crime was stalking, to do with seemingly his wife. And it was all surrounding addiction and that sort of thing. It makes sense to me, rather than going to jail, prison. I don't know the difference. I always get confused because to us, jail and prison is the same thing. It makes more sense to go and get the treatment, then go into sober living. He's not going to reoffend, most likely. What I did disagree with is them bringing up that he didn't drive and he hasn't been on the roads. But remember the first one we watched, he had 5 drinks before he had driven to court. And that was part of the concern. So I don't like that. I think in like the grand scheme of things, if he gets sober, that's not something to worry about. But I also don't think it should be like discounted. He looks so much better, but very, very skinny. Presuming that's the detox. And I hope that whatever updates they get next week, we get as well, because there's at least 6 of us that have Heenan as the screensaver of our minds. Anyway, the premier's just started and I'm not there. So I'm going to say goodnight and I'm going to send you there, and I will see you in the chat. I'm so glad we got to see that positive update, even if it was kind of teary, even if Judge Simpson cried again. Yeah, I'll see you at the premiere. Bye.